Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. In this video, we are dealing with the third part and a continuation of our discussion in relation to the law and employment. Before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. We continue this discussion by talking about breach of a contract of employment, termination of a contract of employment, and issues of redundancy. And then we are also going to talk about severance, benefits, and gratuity when these contracts of employment are terminated. And then finally, we are going to be talking about dispute resolution in relation to termination of an employment contract. An employee is considered to be in breach of an employment contract if they fail to go to work. And in failing to go to work, they do not have a good reason for doing so. And an example is where a person says they are sick. They spend a week not going to work, and then after a week when they go back to work, they have nothing to prove that they have been sick all this time. Then this employee is considered to be in breach of the employment contract. Because remember, an employee demonstrates that they have been sick by giving a certificate from a medical practitioner which accounts for the entire period that they have not been at work. An employer is considered to be in breach of an employment contract if they fail to pay wages. That is, if they don't pay the salaries of employees, then they are in breach of the contract of employment. And if this breach causes the employment contract to come to an end, then the innocent party has to be paid by the guilty party or the party who was in the wrong. An example is if an employee hasn't gone to work and does not have a good reason for why they didn't go to work, then the employer might decide to terminate the employment relationship. And in terminating that employment relationship, the employee would then have to pay the employer for such termination. And such payment would be judged on a case-by-case basis. Similarly, if an employee terminates an employment contract because the employer was in breach by not paying them their wages, then the employer will be liable to pay the employee for this breach that caused termination. And this leads us to our next topic, which is termination of an employer-employee contract or agreement. There are various ways that an employer-employee relationship can come to an end through the termination of this contract. An employer-employee contract can terminate where a contract is for a specific piece of work. So if an employer hires an employee to help them build a house, for example, at the end of building this house, then the contract automatically comes to an end. Or if the contract is for a period of time, which is usually what is called a fixed term contract, then at the end of that contract, if the parties do not renew it, the contract comes to an end or is terminated. Or a contract can be terminated where it is not for a fixed term period, where there's an unspecified period of that contract. And usually this applies to permanent and pensionable employees or even if the employee is not pensionable when they are a permanent employee. Or it can be terminated early where it's for a piece of work or for a specified period of time by the employer or the employee for various reasons. But we're going to discuss termination first on the context of the employer and the rights and duties that flow from there, and then we will be dealing with termination in respect of the employee. An employer can terminate an employee's contract of employment if the employee is in breach of the contract as previously stated, and by terminating this employee, the employer has to give the employee notice, and this notice will be equal to the cycle of wages. And this is done in order for things to be simplified. There are instances where an employee can be given 1 month's notice, can be given 1 day's notice, 1 week's notice, 2 weeks' notice, and so on and so forth. But in order for you to just avoid any issues, because remember, the wage cycle cannot be less than 1 week and cannot be more than 1 month. So if you just tie the notice period to the wage cycle, you will be on the right footing. The only difference is where an employee has been working for an employer for 10 years or more. No matter what the wage cycle is, if this employee has been working for that employer for a continuous period of 10 years or more, then the notice that has to be given by the employer to that employee cannot be less than 6 weeks. And during that 6 weeks, the employee will continue to do the job that they were hired for. However, the employer can also decide to pay this employee instead of having the employee serve notice. The employer, in deciding to terminate this employee's contract of employment, can do so without giving reasons, but they do this at their own risk. And the only time the courts have recognized this is if the matter in relation to termination of the agreement is taken to the High Court. The High Court has said if you terminate and you give the necessary notice, you don't have to give reasons. However, most employees go to the industrial court. And because of that, at the industrial court, the employer must have demonstrated that they had good reasons for terminating this employee's employment. And these good reasons must also be followed by a demonstration that the proper process for termination of this employee's employment was followed. There are instances in law, however, where an employer is entitled to terminate the contract of an employee without giving notice or payment if there are instances of serious misconduct. But we will discuss serious misconduct later on in this video. So if an employer decides to terminate the contract of employment, there must be due process, meaning one, if an employee is permanent and pensionable or permanent, or if it's for a piece of work but it's terminated early, or for a set period but it's terminated early, then the employer must say why. And it should be a good reason. It could be issues of the employee has not been working properly, or the employee is not fit enough to continue in this job depending on the type of job, or when the employee has been on sick leave for an extended period of time. They've exhausted all their leave days, both sick, annual, and now they've been on unpaid leave for an extended period of time. Or where the employee is guilty of misconduct. Not serious, but just misconduct. then the employer might decide to give the employee a warning the first time, and then the second time that the employee is guilty of misconduct, then the employer might decide to let the employee go or terminate their contract of employment. And in doing so, the employer must follow the necessary process. That is to effectively advise the employee that they have this issue to face, which is, for lack of a better word, a charge at work. To say, you're guilty of misconduct, or you have been ill for an extended period of time, and I'm starting this process to show that I can't continue with you in the relationship, and therefore there must be due process. If these two things are not there, and these two things are called procedural fairness and substantive fairness, which are the crux of issues that go to the industrial court where there is a dispute between the parties, which is usually the employee who is unhappy with how they were let go at work, and they then say, I need this issue to be addressed. And one fundamental thing that people have to know is that at the industrial court, once the employee has demonstrated that they have been fired, then it is the duty of the employer to show that in firing this employee, they had a good reason, one, and then two, they have to also show that they followed a fair and proper process. If they fail to demonstrate these two things, then the termination of the agreement of employment is considered to be unlawful, and therefore there are various orders that the court can give against the employer. An employer cannot terminate the employment of an employee for certain reasons that are specified in the Employment Act. They cannot terminate an employee's employment because of their participation in a trade union or being a member of a trade union, because of their gender, sexual orientation, their race, their creed, their ethnicity, their religious beliefs, and so on. So the list is there. You can go and look at the Employment Act. It's quite a detailed list. Serious misconduct in terms of the Employment Act has been defined, and this definition is made by way of giving examples. And examples of these are willful disobedience of lawful instruction from the employer, and the employee simply refuses without any good reason. And that is why it's called willful. And issues of dishonesty. If an employee steals from the employer, if the employee steals from the employer's customers and things like that, you can go to the Employment Act to see the list. On the part of the employee does not have to give a reason for why they want to terminate the employment relationship. As long as they give the necessary notice, or as long as they pay the employer in lieu of this notice, then the employee can decide to go and work elsewhere. Where an employee's contract of employment comes to an end, then there is a duty on the employer, regardless of who brought that contract to an end, to issue a certificate of employment. And this certificate will have the name of the employee, the duties they were carrying out, and how long they were with that employer. And the employer cannot say anything bad in that certificate of employment. The certificate of employment is issued at the request of an employee, and the employer cannot refuse. An employee is also allowed to terminate a contract of employment without giving notice or giving payment in lieu of notice, where the job is starting to endanger the employee or the employee's family members, where the job that the employee was hired for now changes into something completely different, where the employer makes it difficult for the employee to continue to do their job, where the employer wants the employee to move somewhere else and it's not contained in the contract between the parties that the employee will be required to move from time to time and things like that. So in those instances, the law actually allows the employee to just terminate their employment then and walk out without a need for the employee to serve notice or to pay anything in lieu of notice. The next issue I want us to talk about in relation to termination is that of redundancy, commonly known as retrenchment. This is where an employer wants to reduce his or her workforce. Where an employer decides to reduce this workforce by way of retrenchment or redundancy, then this process will be carried out in a specific manner. And the manner of carrying out this process is that once the employer forms the intention to reduce the workforce, then they have to notify the Commissioner of Labor, and they have to notify each employee that is likely to be or will be affected by this retrenchment or redundancy. And the way that the retrenchment has to be carried out is based on each category of employee and on the principle of first in, last out. This is to say, when a person was hired first, then they should be the last person left out, the last person to be let go as part of the retrenchment exercise. However, this is subjective. And the reason why it's subjective is because there are certain employees that might have been with the organization for a long time, but they don't have a certain element of skill that is brought in by an employee that came at a later date. So let's say, for example, 2 employees are hired as lawyers. The first employee that was hired was a lawyer that specialized in drafting of contracts. And then the second employee is one that was hired in respect of general law, where they are a jack of all trades. You throw them in contracts, they do it. You throw them in conveyancing, they do it. Then an employer that assesses this situation might say, it's easier for me to let go of this attorney that only specializes in contracts, because this jack of all trades will be able to continue work widely and service a larger number of our clients than one who is only specialized in one area. So it all depends on the assessment carried out by the employer. And where the retrenchment exercise or redundancy does take place, then within 6 months of that happening, the employer then floats a position for an attorney, if we continue that, who is fantastic at drafting. And for clarity, a redundancy might be because of a situation at play. So if within 3 months the situation is back up again and they're running optimally, then the position must be offered to the person that was let go as a result of redundancy or retrenchment. If the employer does not do this, then they are guilty of an offense. But the employee can decide, I found a new job, I'm not going to come back. That's when the employer can decide to employ other people that were not part of the redundancy or retrenchment. But this only applies for 6 months. After the 6 months, then the position can be taken on by anyone with the necessary advertisements, or however the employer decides to recruit new people to their organization. When an employee's employment comes to an end, then this employee is entitled to a payment of severance, but they are only entitled to payment of severance if they are not entitled to a gratuity or a pension, or both gratuity and pension. The way in which severance is paid is that severance is paid at the end of 60 months of continuous employment with a specific employer. So 60 months is 5 years. If an employee has been working with or for an employer for 5 years, at the end of that 5 years, then the employer should pay this employee what is called a severance benefit. And the severance benefit is calculated at 1 day for each and every month worked. And this 1 day would be basic pay at the time that the severance benefit is payable. So if the employee on the first month of employment, they earn 100 pula. And at the end of 60 months, they earn 1,000 pula. Then the severance pay will be based on the basic pay for 1 day of that 1,000 pula. Then they will be paid the basic pay for 60 months. So that would be a total of 60 days because it's 1 day every month. So it would be 60 days times 1 day of pay at the rate of 1,000 pula per month. So you have to calculate what the basic pay for 1 day is on a monthly basis and multiply that by 60. If the employee continues with that employer for another 60 months, that will make a total of 10 years. For that second set of 60 months, the basic pay will be of 2 days. And the calculation will be based on the pay at the end of the second 60 months. If an employee's employment is terminated, whether it's before or after the 60 months or before or after 120 months, then the severance is paid on a prorated amount. So if an employee has been only working for an employer for 2 years, for example, then the severance amount would be 24 days for every month worked for that employer. However, an employee is not entitled to severance payment as said when they are entitled to gratuity. And gratuity is a gift that is paid by the employer to reward an employee for their service, to say thank you for your service effectively. And gratuity will be set out in the agreement between the employer and employee. Similarly, if the employee is entitled to a pension, then they are not entitled to a severance pay. However, the parties can, in their contract of employment, agree that this employee will get all of it. They'll get severance, they'll get gratuity, they'll get pension. There's nothing in the Employment Act that prevents that. However, in terms of the Employment Act, an employer can only give an employee more than what is in the Act, but they cannot give an employee less than what is in the Act. In other words, an employer and employee cannot agree that the employee will have less leave days. They cannot agree that the employee will have less rest days, will have less benefits, and will not be entitled to severance, gratuity, pension, nothing, and things like that. If an employment comes to an end, the employee, as stated before, is also entitled to payment of any leave days that have not been used or that have not been forfeited. These leave days do not form part of severance. They are just payments there, and they are made regardless of whether the employee is entitled to severance or gratuity or pension, as long as the leave days are there and they haven't been used or forfeited. The last thing I want us to discuss in this video is dispute resolution, where there is an issue in relation to employment. And this issue could be when an employer and employee relationship still exists and the parties are not able to agree, or where termination has taken place and the parties are not agreeable on what is to be paid out and things like that, or if someone says the termination was not done properly. And the way that this is done is And I'll give an example of termination because that is the easiest one to understand. If the employer terminates the employment of an employee and the employee believes that the termination was not done properly, then this employee has 30 days within which to file a complaint or refer the dispute to the Commissioner of Labor. And once the dispute has been referred to the Commissioner of Labor, then the employee will also serve a copy of this referral on the employer. Thereafter, the Commissioner of Labor or his duly appointed representative will appoint a mediator to deal with this trade dispute. And the mediator will then notify the parties of where the first mediation will take place, on which day, what time, and that their mediator will be person X. The mediator then can meet these parties however many times is necessary, as long as they make a decision within 30 days of receiving this referral. If it is not done within 30 days, then the mediator will issue a certificate to state that the mediation could not be decided within 30 days, or to say the parties have settled if they've settled, or that the parties have no prospects of settling in this matter. And this certificate is what is then used if it says the parties couldn't settle or so on, is then used by the party who is unhappy about the decision, and it's taken to the industrial court. Of course, the Act also applies, and here when I say the Act, I'm talking about the Trade Disputes Act. Now we're no longer dealing with the Employment Act, we're dealing with the Trade Disputes Act. The Act also says this dispute can be dealt with by way of arbitration instead of going to the industrial court. But in this instance, I will only be dealing with the industrial court because that is where people usually take their matters. And at the industrial court, the court will ask, at the industrial court, the person who wants the matter to be dealt with will file and serve what is called a statement of case. They will file it within 30 days of the issuance of certificate of failure to settle. The statement of case should also be served within 30 days of the referral of failure to settle. And then the party who is against this matter will file what is called a statement of defense and serve it on the applicant, who is the one that brought the matter at the industrial court, within 14 court days of receiving the statement of case. In the statement of case, the employee, let's say the person who brings the matter is the employee, will set out what the issue is and what it is they want. And usually it is an issue of them saying, I wasn't terminated properly, I was terminated on this day, and so on and so forth. And then the employer, in defending or opposing the matter, will say, no, the employee was terminated, but the termination was done properly, and give reasons why they say it was done properly. Parties are allowed to be represented at the industrial court, even by attorneys, unlike at mediation, where parties cannot be represented by lawyers. They can be represented by co-workers or union representatives, but not lawyers. And then once the statement of defense has been issued, the matter can be set down for further mediation and case management before the registrar or a mediator at the industrial court. And if it's a case management, there will be a report prepared by the parties or by the registrar to be signed by the parties and filed with the court. There will be filing of additional documents called discoveries, and then the parties will be allowed to call witnesses to move their matter after filing discoveries, and so on and so forth. In my next video, I will be taking you through the various processes and papers properly to be filed by the parties in relation to an industrial or trade dispute in this matter. Thank you for joining me. Join me in the final part in relation to the law dealing with employment. Please like, share, subscribe, ring the notification bell so that every time I put up a video, you get notified. Follow me on my Facebook page at Botswana Thinking Law. Follow me on my Twitter at BW Thinking Law. If you want me to discuss anything at all that you feel that I might not have covered in part 1 or 2, then please leave a comment down below, or leave comments on my Facebook page or on my Twitter. I always appreciate hearing from you and your questions and having engagement from your side. Bye.